Ms. Anderson, you are before the court on 3 charges that were arrest warrants issued by Judge Mercurio on traveling to meet a minor, transmission of harmful material to a minor, and sexual battery by custodial authority. State?
Your Honor, regarding criminal history, it does appear that there is a driving under the influence out of Kansas City in 2017. According to NCIC, there is no dispel on that, but it shows that she has ties to other states. Based on the facts in the arrest warrant, the state would be requesting a bond for count 3 in the amount of $200,000.
Okay. Defense?
Your Honor, I don't have an argument as to probable cause as to the counts. I would, however, point out as to count 3, which is the custodial authority count, that pursuant to Hallberg versus State 649 Southern 2nd 1355, which is a 1994 Florida Supreme Court case, in order for the state to meet that requirement of being able to prove custodial authority, they have to show that the teacher and the student had a relationship during school times. The custodial authority happened as a result of them being during the school year. This is a teacher. My reading of the probable cause affidavit seems to indicate that the vast majority of what has been alleged occurred during the summer. Hallberg is exactly that situation where the Florida Supreme Court said doesn't qualify under that. There is one incident, I think that there's an allegation from 8/20 of this year, which I believe is during the school year. But for purposes of probable cause, I'm not necessarily making an argument that this doesn't meet probable cause. It's just as far as weight of the evidence is concerned, where this may ultimately end up being, instead of the first-degree felony, it may ultimately end up being the second-degree felony, which is unlawful sexual activity with a minor. And that changes things a great deal. But additionally, Ms. Anderson does reside here. She is married. She's 38 years old. She has no prior history of violence. She's never missed a court date. She has a 6-year-old son. She owns a home here. She's been living here since 2018. She was nominated for Teacher of the Year in 2016 in Holden, Missouri. She is the holder of a master's degree and is currently in the process of gaining a second master's degree. She was working full-time, obviously, prior to this. She's since been let go from the school that she was working at, which plays into the issue of a reasonable bond issue. She had summer residency in Portugal. She has a very stable home environment. She turned herself in on this. She went down to the jail and turned herself in, so this is not a flight risk. She does have a passport. We would be agreeable with any conditions of supervised release, of turning over a passport, any kind of monitor that the court wished to put on her, and no contact with minors other than her own child, who is 6. The allegations in this are that the alleged victim is 17 years old. He will be 18 in March. And again, I would just ask that because she was screened for supervised release, because she was deemed acceptable for supervised release, there are bonds currently on counts 1 and 2. Count 3 comes with a presumption of no bond. We are asking for a bond that they can make on that count. I would be asking for $25,000. I would argue that pursuant to State ex rel Bardina versus Sandstorm, 321 Southern 2nd, 630, it's a Florida 3rd District Court of Appeals case, and State ex rel Crabb versus Parson, 189 Southern 2nd, 376, that's a Florida 1st District Court of Appeals case, where the court, in setting a cash bond, should set a bond that meets 2 criteria. That is, 1, to protect the community, and 2, that it's a bond that the defendant can make and can ensure their appearance and safety of the community. And in this particular defendant's case, in light of all of the factors that are involved here, I would think that a $25,000 bond on this, with the 10 on count 1, and I think it's $1,500 on count 2, that would ensure her presence in court. And then, of course, supervised release in any conditions, no contact with minors, GPS monitoring, anything else that the court would like to place on it.
Thank you. Well, I certainly appreciate the well-reasoned arguments presented by defense counsel. Judge Mercurio issued the warrants in this case, and he was very explicit in that, as to count 3, that bond, if any, needed to be set at an Arthur hearing, as he found probable cause of a charge for the crime punishable by life in prison. So at this point, I'm going to maintain the no bond on count 3, deferring to Judge Mercurio, and maintain the bonds as to count 1 and 2 as set by Judge Mercurio with supervised release. And he indicated very specific criteria with regard to the supervised release, and he outlined that in the warrants as he issued. So I'm going to maintain those. Certainly, a motion in front of Judge Mercurio can be set so that further arguments can be made, but I'm going to defer to his findings when he issued the warrants.
And Your Honor, for purposes of the record, I'm going to make an argument, and I'll take this up with Judge Mercurio, that the difference between this count and those counts that qualify for Arthur, this is not a mandatory life sentence. This is punishable by up to life, and I don't think it fits the statute under Arthur. But I will address that in a petition for habeas.
Okay. Thank you. Best of luck to you, ma'am.